on them to pay greater attention and respect the right to health in their lending policies and credit agreements. Thirdly, by ratifying an international human rights treaty such as our CESC, or the Convention on the Rights of the Child, state parties are obliged to align their domestic legal order with the commitments in the provisions of the treaties. It is impermissible for states to invoke a provision of their domestic law as a reason not to comply with an international treaty. They are obliged to repeal and revoke laws or policies that are inconsistent with their treaty obligations, and are obliged to adopt positive measures to fulfill, promote, and respect and protect the relevant rights. So, having sketched very briefly the legal status of international obligations imposed by the right to health, or the evolution of right to health in international law, I turn now to consider the content and nature of the obligations imposed. The first starting point is that, as is the case with all human rights, the normative content of the right is fundamentally informed by the value of human dignity. This is recognized in the preamble of the Universal Declaration of Human Rights, as well as the preambles of all the core UN human rights treaties. Human dignity as a normative value underpins the interdependence between civil and political rights and economic, social, and cultural rights, and it informs what we mean when we say that everyone has the right to the highest attainable standard of health. So in its opening words to General Comment 14, CESC says that health is a fundamental human right, indispensable for the exercise of other rights. Every human being is entitled to the enjoyment of the highest attainable standard of health, conducive to living a life in dignity. So dignity is really the lodestar which informs the normative content of health rights. And this has important implications for us. Fundamentally, it implies a recognition of the worth and value of every human life, and that people are entitled to be active agents and participants in the major decisions that affect their lives. In the context of the right to health, this implies that certain procedural obligations are fundamentally important in giving content to this right. This includes the right of communities to participate in the development of health policy and plans, access to health information, as well as procedural fairness in health decision-making. CESC has emphasized the importance of participation in many dimensions of health policy and decision-making, underscoring how fundamental it is to conceptualizing health as a human right. It has, for example, said that promoting health must involve effective community action in setting priorities, making decisions, planning, implementing, and evaluating strategies to achieve better health. Effective provision of health services can only be assured if people's participation is secured by states. I feel very passionately about this dimension of socioeconomic rights, because so often socioeconomic rights are perceived as commodities to be delivered to passive citizens, service delivery, as is the one in South Africa to refer to this, rather than conceptualizing these rights as including entitlements to voice and agency in the laws, policies, and decisions that affect the right. This point has also been very much underscored in the most recent statement of the committee, looking at the implications of adopting a rights-based approach to the realization of the 2030 Agenda on Sustainable Development, i.e. the SDGs. Flowing, secondly, from the idea that human dignity lies at the normative core of the right to health is also the idea that respect for personal autonomy is important and significant in framing the right to health. Autonomy implies respect for the bodily integrity and personal choices of an individual or group, and it provides support for, amongst others, fundamental norms of health rights such as free and informed consent for medical treatments or experiments, and for sexual and reproductive health rights. In its general comment number 22 on the right to sexual and reproductive health, the committee noted that the right to sexual and reproductive health is indivisible and interdependent with other human rights. It is intimately linked to civil and political rights, underpinning the physical and mental integrity of individuals and their autonomy. In a recent communication decided by the committee under the newly come into force optional protocol to the covenant, SC and GP versus Italy, well illustrates the role of autonomy in the protection of health rights. This communication or case concerned a woman and her partner who had undergone in vitro fertilization in Italy in the hope of conceiving a child. However, pre-implantation genetic diagnosis revealed that all but one of the 9 embryos produced during the IVF cycle was affected by a hereditary genetic disorder. However, this one embryo was graded average quality and had a low chance of nesting if transferred to the uterus. And many of us on the committee had to be learn to understand that average quality did not mean average health or average intelligence, but the potential of resulting in a successful pregnancy. So the author declined to have the embryo of average quality transferred to her uterus. However, the clinic's personnel insisted that Italian law in Italy regulating assisted reproductive technology required that consent could only be withdrawn prior to fertilization of the embryo. And under the threat of legal action, the woman reluctantly agreed to have the embryo transferred to her uterus, suffering shortly thereafter a miscarriage. So this complicated technology, this complicated communication raised many questions and was brought before the committee on many grounds, but fundamentally the committee found that the implantation of the embryo under threat of legal sanction was a coercive medical intervention and failed to respect the woman's right to make free and informed decisions concerning medical treatment. It failed to respect her autonomy, thereby violating the right to health under Article 12 of the Covenant. The third implication of seeing human dignity as lying at the foundation of the right to health concerns the right of respect that flows from human dignity, of regarding each human being's unique life choices and circumstances as being worthy of equal value. This commitment, says the committee, should inform the design of social, economic, political, and cultural institutions so that they are responsive to the different situations and contexts of individuals and groups. This implies, for example, that a one-size-fits-all approach is not appropriate for the design of health institutions and facilities. Thus, for example, the committee has held that health facilities and services should be culturally appropriate in the sense of being respectful of the culture of individuals, communities, indigenous peoples, as well as being sensitive to gender and life cycle requirements and differences. So this equality dimension of the right to human dignity finds expression in the right to non-discrimination in the delivery of health services and benefits, which is enshrined as an autonomous right in Article 2.2 of the Covenant. But it also extends beyond the idea of non-discrimination on grounds, for example, of race, ethnicity, gender, HIV status, sexual identity, etc., to encompass the elimination of broader systemic inequalities in the health sector, including equalities in the enjoyment of the right to health between rich and poor, both within and among countries. In this context, the committee has emphasized the obligation of state parties to ensure equality in access to healthcare services, particularly for impoverished groups. Thus, economic affordability and accessibility have been identified by the committee as one of the essential elements of health as a human right. And this requires that payment for health services, as well as services related to the underlying determinants of health, such as water, should be based on the principle of equity and ensure that socially disadvantaged groups are not disproportionately burdened with health expenses compared to rich households. The committee has also observed that health inequalities can also arise from inappropriate health resource allocations, even if there is no overt discrimination. For example, investing disproportionately in expensive curative services at the expense of primary health care and benefiting a larger proportion of the population. And finally, attention has also been drawn to gross global health inequalities, which the committee has described as politically, socially, and economically unacceptable, and therefore of common concern to all countries. In this context, it has expressly endorsed the 1978 Alma Ata Declaration arising from the International Conference on Primary Health Care, and affirmed that in the context of the Covenant, Article 2.1, international assistance and cooperation are incumbent on every state party, including the duty of developed countries to assist developing countries in fulfilling their core obligations under the right to health. So I hope that these few examples drawn from the exercise of the committee's interpretive and monitoring mandates have demonstrated how human dignity and its related values of autonomy and equality are the lodestars that guide the normative content and obligations imposed by the right to health. On this foundation, the committee has constructed an elaborate set of contents and entailments for the right to health, as well as a complex set of normative obligations for states relating to their domestic law and policy, as well as their international obligations. One critical dimension that I should also emphasize in this context that distinguishes health as a human right from simply a political or ethical moral commitment is the fact that it demands accountability for its breach. This has been something which has been emphasized by the committee. Accountability can take many forms through health ombudspeople, through human rights commissions, and through a free media, civil society organization, patients' rights organizations. But the committee has also underscored the essential role of justiciability of the right to health, as well as ensuring that adequate, effective, and timely remedies are afforded to victims of violations of the right to health. In the last 5 minutes that are remaining to me, I will briefly focus on 3 topics which may be of special interest to the deliberations of this conference. The implications for private actors of the right to health, extraterritorial obligations, and limitations of health rights. So firstly, one of the fundamental duties that states undertake when they ratify the covenant is to protect the right to health against the actions of third parties, private parties that could undermine the right to health. This requires the adoption of regulatory legislation. It requires ensuring that the private sector is properly regulated, that the codes regulating the medical profession, medical equipment, complies with the necessary qualitative and quantitative standards. And I can just, because time is not on my side, highlight the very important recently adopted General Comment number 24 of the committee, which concerns the implications of covenant obligations for business activities, having a huge implication for private actors, pharmaceuticals, and others in the private health sector. Secondly, as I've already touched on, the right to health also has an extraterritorial dimension. And this means that states must ensure that they, as well as third parties under their jurisdiction, control that they do not undermine the right to health in other countries. In addition, they have joint and individual responsibility to cooperate in providing disaster relief, humanitarian assistance, and to cooperate with each other in reducing epidemic and pandemic diseases. And finally, what happens when rights clash with each other or have to be limited for compelling reasons of public policy or safety? As the concept note to this conference points out, measures to control the spread of epidemic diseases may result in restrictions of personal autonomy, such as freedom of movement or even free consent to medical treatments, such as quarantines and immunizations. The right to health is both a potential subject of limitation in various contexts, and the protection of public health can provide a reason for limiting other rights, as I've mentioned, freedom of movement. These limitations are expressly regulated by provisions in international law and by specific provisions in the Covenant, particularly Articles 4 and 5. And essentially, they set out a 5-part test which limitations both to health rights and for using public health as a pretext for limiting other rights must comply with. Briefly, the limitations must have a legal source. They must be prescribed by law. They must be for a compelling purpose that is compatible with open democracy. They must be compatible with the nature of the right. they must be proportional in the sense of being narrowly tailored to the goal that is sought to be achieved, and not go further than is necessary in the circumstances. And they must, where a number of measures are available, they must select the least restrictive measure of limiting the right. So in conclusion, I hope I have succeeded in conveying the broad contours of health as a human right under international law. As Stephen was saying in his opening address, human health and well-being is complex and multifaceted. It is affected by every aspect of our life on planet Earth. It certainly cannot be contained or responded to adequately within national boundaries. It faces huge contemporary global challenges, such as increasing wealth gaps, rapid technological changes, global migration and refugee flows, armed conflicts, antimicrobial resistance, new epidemic diseases, and the ever-deepening scourge of non-communicable diseases, as well as perhaps most prominently the absolutely cataclysmic challenge we face to life here on Earth of climate change, loss of biodiversity, and other related environmental threats. So our understanding of the right to health and its entailments will have to evolve to respond to these phenomena. However, I firmly believe that the normative foundations of the right to health in human dignity and the structure of the obligations which have been constructed by our committee and other committees at national and regional level provides a sound structure for developing appropriate responses to these global challenges. This conference represents an important initiative to extend the frontiers of global health law. I wish you well in this endeavour, and I trust that your deliberations will be firmly rooted in the tenets of health as a legally binding human right. Thank you.
Thank you very much, Professor Liebenbeck, for the comprehensive keynote address. This conference is being live streamed, and you looked great on camera. And for those that have...
Even if what I said wasn't great.
It was great. For those that have Facebook and access to YouTube, you can share it. UCT Law, so it's looking quite good. The next session is shared by Professor Benjamin Mayer, and unfortunately we have the presentation from here, so the speakers want seat here, so you invite one by one. Thank you very much.
Thanks so much. Drawing on in many ways Professor Liebenberg's stirring words on the importance of dignity as a foundation of the human right to health, I'm delighted to welcome you to the opening panel of the Global Health Law Conference, addressing South Africa's role in informing health and human rights. South Africa is widely viewed as a global leader in efforts to realize human rights in health, with its constitutional commitment to the right to health serving as a beacon to the world. I'm delighted that we're beginning this global conference by addressing South Africa's influence. Good morning. I'm Benjamin Meyer, an Associate Professor of Global Health Policy at the University of North Carolina at Chapel Hill. And I'm honored to introduce and moderate this opening panel. Grateful for the leadership of Danwood, Stephen, Brooke, bringing us all together today and developing this full day of groundbreaking discussions to start our consensus conference. Our opening panel will begin by examining the implementation of human rights in South African health policy, where the anti-apartheid struggle became intertwined with the assertion of a right to health for all. Policy over the past 25 years has sought to develop a people-driven movement for health, developing a rights-based approach for health as a foundation for equity. Drawing inspiration from Professor Liebman's certainly expert thoughts on global health law, thoughts on the evolution of a right to health and the purpose of dignity as a foundation of that right. This panel will consider how human rights have been implemented in South Africa's health system, and what these developments mean for the future of health and human rights. I'm delighted to introduce the four speakers on our opening panel, who I will introduce collectively now and then bring up individually to make their presentations. Speaking first about the groundbreaking influence of the South African Constitutional Court in facilitating accountability for the right to health. We'll hear from Lisa Foreman, a research chair in human rights and global health equity at the University of Toronto. From there, Jerome Singh, the health of ethics and law at the Center for AIDS Programming of Research in South Africa, will speak about the influence of human rights and HIV research in South Africa. Focusing on one specific type of research, Donrich Thaladar, the senior lecturer in law at the University of KwaZulu-Natal, will speak about the regulation of human genetic engineering. And we'll end by discussing the resource implications of the right to health, with Gorik Ooms, Professor of Global Health Law and Governance at the London School of Hygiene and Tropical Medicine, discussing South Africa's Supreme Court's expectations of reasonable expenditure within available resources. With each of our panelists speaking for only 12 minutes, I'm delighted that we will have a full half an hour for discussions at the conclusion of that opening panel. Now let me invite Lisa up to begin our conversations.
Good morning, everybody. It is a tremendous pleasure to be in this room with many of my global health and human rights colleagues who I've met, many who I haven't. Thank you, Stephen, for inviting me to participate in this conference. Thank you, Dan Wood, for hosting us so graciously, and the rest of the organizing committee for a really tremendously enjoyable lead up to this experience. It's also a tremendous honor and a privilege to be coming up after Professor Liebenberg. I've been reading you for years, and when I went back into my doctoral dissertation to refresh myself with, the constitutional drafting and extant, or certainly what was extant 12 years ago, interpretations of the Constitution, any interesting relevant point that I found was footnoted to you. So. It is a great pleasure. For graduate law students here, this is a tremendous opportunity to meet people you might want to external your PhDs or do postdocs with, and I encourage you to come and talk with the people here at every opportunity today. It's a tremendous pleasure for me to be here considering South Africa's contributions to health and human rights, both as a South African lawyer who came of age as South Africa's post-apartheid constitution came into operation, and also as a scholar who focuses on the right to health in international human rights. But you don't have to have those kinds of links to be cognizant of South Africa's role in this area. South Africa is clearly a key jurisdiction when it comes to economic, social, and cultural rights like health, and it's had outsized influence on international and domestic law. And I'm going to touch on some of that today. South Africa's constitutional experience with the right to health, I think, touches on some really fundamental, sometimes existential questions at the root of the right to health about how rights form through the interaction of law, politics, and social movement, and fundamentally about the capacity of the right to health to realize its promise at its core of every person's having equal access to good quality and affordable healthcare and experiencing good health, and of the capacity of that promise to then guard against illegitimate trade-offs in service of competing interests, particularly when the legitimacy And the utility of this right remains deeply contested in many parts of the world. And when the dominant paradigms of policy, politics, the private sector seem to favor almost anything but affordable healthcare or health equity. So I'm going to focus really on a very small part of this larger story. I'm going to very briefly overview some of the ground that Professor Liebenberg already elaborated, and really consider the dialectic between the development of the international human right to health and the emergence of this right in South Africa, and what this interaction suggests about the future of this right, particularly in the present moment when health inequalities are worsening in many parts of the world, and larger political upheavals are throwing many of the norms and conventions underlying the international human rights law system into question. So it's always, I think, good to contextualize the timescale of law that we're looking at. And to remember how new scholarship and practice around this right is. It was only 40 years ago that international human rights experts, when speaking about the right to health, thought it was out as meaningless to talk about a legal right to health as it was to talk about a right to be in love, a right to wisdom. And we've come a tremendously long way from there. Where people would think of the right to health as obviously a good thing, but not necessarily the appropriate domain of law and policy. Now, a lot of the challenge in this area, if you engage with international law, comes from the interplay of these two aspects of the international covenant. The fairly expansive right to health in Article 12, which is the recognition of every person's right to the highest sustainable standard of physical and mental health, and then how to interpret that expansive right in relation to Article 2.1, which limits state duties to progressive realization within maximum available resources. And Article 2 was critiqued even at the drafting of the covenant as a weak guarantee that could potentially give far too many loopholes to states to evade or delay their obligations by pleading a lack of resources. So we've come a tremendously long way in the legal force and the content of this right. We've had a tremendous growth in the quantity and force of international and regional instruments which recognize health rights in various forms and for specific populations, racial minorities, women, children, indigenous people, people with disabilities, and more. And as Professor Liebenberg indicated, almost all countries in the world are bound by one or more treaty, international treaty containing health rights. At the same time, over 100 countries have introduced constitutional protections of these rights. And what we're seeing with these overlapping legal regimes are that what they're doing at the domestic level is producing a far stronger legal framework for civil society and individuals to rely on in bringing domestic claims around the right to health. And the result of this is that we've seen a tremendous explosion of right to health litigation over the last 20 years, where people are increasingly approaching courts to claim access to medicines, to healthcare, to housing, education, food and water. Now, the legalization has been assisted tremendously by the interpretation, especially General Comment 14, which offered the first international human rights explanation of what a legal right to health entails, explicating normative content, core obligations, essential elements, the rights and duties. For those of us in this field, the general comment is somewhat biblical, and that really is, I think, an accurate way to describe it, because how you feel about the general comment might depend on how you feel about the Bible in general. It is also, and I say this because I think there are elements that are quite controversial, particularly its interpretation of core obligations under the right to health, which, for reasons that I won't get into now, but I'm happy to discuss in the Q&A, are fairly seen as potentially unsustainable. So the inclusion of justiciable social and economic rights in South Africa's post-apartheid constitution draws in significant ways from this larger body of international law. Although obviously South Africa's relationship to international human rights law has all the uglier roots in the body of South African law's response to apartheid, which was a legal system completely antithetical to human rights. and which effectively created a template for a completely contrasting post-apartheid constitution aimed at repairing and transforming South Africa into a responsive, accountable and open democratic state based on equality, dignity and freedom, a refrain that appears throughout the constitution. And the constitution protects a wider range of human rights than would ordinarily have been seen in a constitution, certainly at the time that it was entrenched. Now, it's notable that economic, social and cultural rights were strongly contested here, even at the constitutional drafting. And while those debates reflected the conflicting political imperatives to either preserve or transform the status quo, within academia they also draw on broader legal concerns about the practical, institutional and democratic perils of entrenching social and economic rights as impossible. And those are critiques that remain pervasive and deeply rooted, particularly in North America. In Canada, despite the fact that it has a publicly funded single-payer health system that in many respects de facto realizes the right to health, the legal system is strongly rooted in this older paradigm in which economic, social and cultural rights are seen as second-generation positive rights, expensive rights that are completely different from civil and political first-generation negative, ostensibly free rights. And so the Charter in Canada doesn't entrench these rights, and the Supreme Court is fairly committed to refusing to recognize a positive duty to provide health care. Now, in South Africa, these arguments obviously weren't successful given the inclusion of a full justiciable set of social and economic rights, which was at the time remarkable. I think it was one of the first common law democracies to international law on the wording of Section 27. It essentially says that the state's primary obligation is to act reasonably to provide basic necessities of life to those who lack them, requiring comprehensive programs focusing on the most vulnerable, especially the poor and those experiencing urgent and desperate needs, and which has been applied in subsequent cases and which is being populated with further criteria through those cases, with criteria that overall you could characterize as aiming at ensuring fair, accountable, grounded policy and decision-making rooted in the human rights priority of protecting those urgent needs of the poor. Now, what's distinctive about the Reasonableness Standard is that it's been taken up by the committee and the ESCR in its interpretation in a number of different ways, most significantly in the standard of review that it has adopted in the optional protocol, where the language of reasonableness was explicitly drawn from South African law. And so for those of us who grapple with the legal formulation and interpretation of the right to health, the committee's adoption of the standard raises really pressing questions. Because in South Africa, although there are very positive seminal decisions like Grootboom, TAC and Koza and others, a decision like the 2010 Mazibuko case is very troubling for its suggestion that as long as the state establishes that it is acting reasonably to progressively realize within resources, then it seems almost any extent of deprivation could be permitted, which certainly seems to be the implication of a decision finding that Johannesburg water policy was reasonable, despite the fact that 100,000 city households still lack access to the most basic water supply. So I'll conclude by saying that if the reasonableness standard is to seed internationally and become a global mechanism for enforcing economic, social, and cultural rights like health, it raises some fundamental questions about how to ensure that the enforcement of the right to health doesn't fall into the trap of accepting deprivation or of offering accountability without justice, which would be the emptiest of constitutional promises. Especially because concepts like reasonableness are not free from the dictates of power. And at Wits Law School in the early 90s, we learned the legal construct of the reasonable man on the Clapham omnibus as the legal standard by which to measure any person's negligent conduct. Something we can immediately look at today and recognize as blind to its gendered, racial, and geographic homogeneity and appropriateness. Now, I'm not suggesting that reasonableness review is problematic in this way, simply that if we are to assess the right to health through a reasonableness lens, we need to pay attention to its capacity to sustain health deprivation and inequity, and pay attention to how power, ideology, contestation might distort interpretations of what constitutes reasonable action, or how far judges are prepared to delve in enforcing these rights. So in South Africa, entrenched rights no longer operate in the interstitial spaces between laws that John Dugard suggested during apartheid, were the only places that apartheid judges could find justice. They're the law itself. And this is an enormously different environment from which to adjudicate rights like health. Consider how differently something like the TAC decision might have looked without a constitutional health right to enable judges to respond to state allegations of judicial overreach on health policy. But what remains in the interstitial spaces between rights and lived reality are the invisible structures that threaten just interpretations of even the best intentioned legal frameworks. And this is true whether we're talking about how gender and racial biases play out in the legal policy environment, or how ascendant norms of neoliberalism can downgrade rights against competing economic and political interests, as we've seen in medicines, including through the concepts, the portal of concepts like progressive realization, considerations of resources. And these are parts of global policy which are dramatically ratcheting up inequality, something we increasingly recognize as destructive determinant of health, as smoking or poor nutrition. So South Africa's experience of the right to health indicates the power of constitutionalized rights, innovative enforcement of the literary one minute, innovative enforcement and social claims, but it also points to the need to build on those claims, to further develop the definition and enforcement of rights like health to better realize the promise of good health and affordable health care, and to better respond to the larger structural pressures on these outcomes. Thank you. No answer, sorry.
Morning, everyone. First, I want to thank Lisa for extending the invite to me to attend this very, very interesting and important meeting. And what I thought I would try to do in my presentation is to bring some of the practical elements of how South African jurisprudence and the Constitution has actually impacted at a very basic level on healthcare in the country, and more specifically in focusing on the context of HIV research and HIV programmatic work. And what I want to do is to show how important cases have actually had a very, very big impact on the lives of people, and how you can actually literally translate human rights cases to life saved. So I just want to take everybody back to the late 1990s and early 2000s. And just to put the context here, we then had a president who was an AIDS denialist and a health minister as well, both whom openly questioned the link between HIV and AIDS. We had about approximately 80,000 babies a year being born with HIV as a result of mother-to-child transmission. And the antiretroviral drug nevirapine was available and was in fact offered to the government for 5 years. But for free, the government did not take it up. And what scientists had been showing at the time using modeling and projections was that we could save 30 to 40,000 children a year if they were given access, if the mothers were given access to nevirapine. So of course the government did not move on this issue, and it eventually resulted in the Treatment Action Campaign, or the TAC, launching a constitutional challenge alleging that this was a violation of the right to access to health services, and they also demanded that the drug be made available throughout the country. So this is what we actually have known before. And what had then happened was that Constitutional Court, as we know in the very famous case of the Treatment Action Campaign case in 2002, rejected the government's appeal because they had lost in an earlier court, and in fact ordered the government to provide nevirapine nationwide beyond the 27 pilot test sites. And I think what's important to note here was that the court went further and said not just expanding nevirapine access, but that to provide counsellors, to take reasonable measures to extend the testing and counselling facilities throughout the public health sector. And this judgment is estimated to have saved literally tens of thousands of lives. And the point that I'm going to make is that it didn't just save lives, and I'll try to show you the figures now, but also that it served to mobilize individuals and groups across the country. And beyond that, it's also spurred and created a very enabling environment for us to conduct HIV research that is now beginning to have global impact, and I'll try to come to that as well. So what has been the impact of the TAC case? Well, it's had a really interesting and important impact on our evolving policy reforms, and it's had absolutely startling impacts on HIV transmission rates. So I just want to take you back to what I mentioned before. In the early 2000s, the estimated HIV transmission rate was about approximately 30% between mother-to-child transmission of HIV. As a result of the policy reforms which were created because of the TAC judgment, the risk of HIV infection has decreased from 8% in 2008, which was already a few years after the court case. It dropped to 3.5% in 2010, and it dropped from 2.6% in 2012 and 2013 to an estimated 1.4% in 2015. This is according to research done by the South African Medical Research Council and a few other role players as well. The country is thus very close to achieving its goal of the virtual elimination of new infections in newborn children, which is defined as less than 2% transmission rate of mother-to-child transmission of HIV at 6 weeks, and around about just under 5% transmission rate at 18 months. So I think that this is the first take-home message, is that it literally has had a very transformative effect on how many children are fighting HIV. But I think also what's important to note as well is that when you look at modeling and you're looking at projections, the national prevention to mother-to-child transmission is estimated to have saved around about 80 to 85,000 babies a year since 2010. This is a huge amount of lives saved because of a court case. I think that what I also want to just mention is that we need to remember that the Treatment Action Campaign case was essentially a case on prevention of HIV. It was essentially a PrEP case. But it's also had a really transformative effect on the country's treatment program. And I think I just need to characterize this again. The TAC case started something. In the year 2000, before the case, there were just 90 people on treatment in South Africa. 90. Following the Treatment Action Campaign case, which didn't get implemented immediately, there were lots of marches, protests, threats to take the minister to court for contempt of court. Eventually the government relented and started to then transform its treatment program. And what that did was, it actually has had an amazing effect, because through the concept of progressive realization, which Lisa very helpfully outlined here, the South African treatment program has gone on from having access and giving access to 90 people to now having more than 4.5 million people on treatment. This is the most of any country in the world. In fact, it represents 20% of all people in the world on HIV treatment is in South Africa. And of course, what we have shown now, UNAIDS has shown and results have shown, is that the number of related deaths in South Africa, and this is research done by the South African Medical Research Council, has dropped from an estimated 293,000, which was 43% of all deaths in the country was HIV linked in 2004 to 200,000 by 2010, and the latest figures, depending on which source you use, UNAIDS says 110,000, the Medical Research Council shows 115,000, but it's basically dropped to between 110 and 115,000 deaths. And this has been the transformative effect of how you have access to treatment being realized in a progressive realization way. So access to antiretrovirals has thus extended the lifespan of many, many South Africans. And in fact, we've now shown that in fact a lot of people who would otherwise have died are now beginning to live a lot longer life. In fact, life expectancy, according to Stats South Africa, or Stats SA, has been increasing every year since the treatment action campaign case. So what has this done now, and how does it impact on healthcare? Well, what I want to actually point out is that the enabling environment of health and human rights in South Africa, and other related clauses like the right to equality and the right to human dignity, has actually allowed a very permissive research environment in the country, where we can now do research in the country that cannot actually be done in any other African setting. So what I want to just point out is that despite all the major progress that we've made, there's still a very high HIV content in South Africa. More than 1,000 people a day get infected. And in fact, the biggest drivers are young women and adolescents, and you have key populations as well. So who is a key population? Well, currently, without going into too much detail, we're largely looking at populations who are at high risk of HIV. They're not part of the generalized epidemic, and we include people who inject drugs, men who have sex with men, transgender persons, sex workers, and prisoners. And you'll find that we really need the evidence to show that these people or these cohorts and groups are at high risk. We need to show evidence because policy making is evidence-based. But you can't show the evidence if you can't do the research. And the problem is that in many African settings, you'll find this type of research is virtually impossible to do, not just because of lack of infrastructure, but because of very discriminatory laws. So you'll find that homosexuality is prohibited in many African countries, including major countries that actually have good research systems. So you find that where South Africa has actually stepped in is to actually create the enabling environment for research on I'm using just these two groups as an example, of very important research to be done on MSM and transsexual women. So how does having a permissive human rights framework facilitate research on key populations? Well, first of all, as I pointed out, it creates a very enabling environment. It allows research to take place that would not be in an environment where the behavior is criminalized. And what I wanted to just point out to you are some very important and interesting studies that are being done. So right now we have very big studies that are being done by the HIV Prevention Trial Network. For those of you who don't know, the HIV Prevention Trial Network is one of the big research networks of the US NIH that conducts research on HIV prevention, not HIV treatment. So it's the second biggest funding network. Its current funding cycle is about $350 million. It gives you an idea of how big the network is. And now they actually after a long time, beginning to look at specifically studies focused on MSM, men who have sex with men, and transgender women. And what's been interesting is that a number of studies have come up in the last few years. So I just thought I'd very quickly tell you about some of them. HPTN 075 is one that looked at the feasibility of introducing PrEP to African MSM. Out of the 400 people enrolled in the study, half of the numbers came from South Africa. The other two sites were actually countries where homosexuality is either unlawful technically or really socially frowned upon. So we had to go into those countries, engage with authorities to allow the research to take place. South Africa, that was not necessary. The other important study that is also being done by the HPTN is a new study looking at injectable HIV drugs. The only site out of the 4,500 participants in the country from Africa is South Africa. So it will contribute very valuable data in terms of whether injectable HIV prevention drugs would actually be effective in an African population. We also have the Human Sciences Research Council, which is the biggest social science council in Africa, doing very important work. The Human Sciences Research Council has a huge budget, but they've now begun to turn their attention to looking at work on where it would be feasible to allow for treatment and also for prevention services for transsexual people in Africa. The only place where this can be done is in the South African context. So essentially what I want to just conclude with is that when research is done in South Africa, it literally, not figuratively, single-handedly impacts on global HIV statistics and UNAIDS programmatic targets. Why do I say this? Well, just to give you an idea, South Africa constitutes just 0.75% of the world's population. With that small population, you'd expect it wouldn't really have too much of an impact on the HIV world. However, the country has 19% of the world's HIV burden. And in fact, while sub-Saharan Africa is now actually 33% of the world's HIV burden, South Africa is actually the biggest component of that. So South Africa has more people living with HIV than the whole of Western and Central Africa put together, the whole of Asia, the whole of Latin America, the whole of North America, the whole of Europe. It's currently 7.8 million people are living with HIV. So what this has done is that when South Africa makes a policy decision, when it impacts and it starts increasing its access to treatment, it really impacts on UNAIDS targets. So without South Africa playing ball, you find UNAIDS doesn't make its targets. How is UNAIDS making its targets or going towards it? It's because South Africa is expanding HIV treatment program as a result of progressive realization, and how we actually ensure that our key populations are being taken care of in the world. It's because of research in South Africa looking at those key populations that cannot be, or very difficult to be researched elsewhere. So essentially that's what I just wanted to make the point, that health and human rights is not a theoretical concept in South Africa. In South Africa, it is having a very tangible impact on people's lives being saved, and it's also not just having an impact locally, it's literally having an impact globally. So I'll just end there and I'll be happy to take questions.